these are all judgments that you're relying on of Article 356. Article 356, qua the role of the governor, stands on a very high footing. The responsibility, accountability is more. Now, we are dealing with the threshold
Well,
under 17A. It is not destabilizing or the government.
No, Malas, it is.
It's article invocation of Article 356.
Grateful for the.
Should this be the
I'm grateful
parameters of consideration?
I'm grateful for the query. Three answers, in fact. It's very
Yes.
grateful. Again, was very relevant. Answer number one, this is our 356 case.
No, the other cases that.
This one is a case where the governor directed a floor test,
Yes.
which Malas would, according to me, considering issues like confidence in the House and majority, are possibly the least reviewable, although I argued successfully in this case, Malas. I would not say it today. But compared to what your Lordship is dealing with, your Lordship is considering review. This is less reviewable in principle. But the review here is much more direct and robust.
No, these are matters where review or the action should be on a.
No, Malas, no, it's the other way around, with respect. Your Lordship's satisfaction on Malas, the filter, it's only a statutory provision your Lordship is to do.
That's what we are dealing with.
Only a statutory provision. Therefore, your Lordship's review
17A.
Suppose, Malas, you replace the governor with the Secretary to Government of India. Why does your Lordship review become less because it's the governor?
No, that's not.
He's in no zone.
No.
He's in no non-reviewability zone.
Interpretation of a statute, yes. The examination is the same.
Materials.
But in a case where judgments which concern Article 356 can we paraphrase those things to a 17A case?
So I have cited three kinds of cases.
Yes, sir.
General power of governor is the first category, Samsher Singh.
Yes.
It is not Malas. It is a general 163 and all that case, Malas. Not a case of either 356 or anything else. Second category, one case is a 356 case.
Yes.
Third category is about floor test.
Floor test. Yes.
Now, I'm asking myself the question. In normal exercise of statutory power by any authority, let us replace the governor with Secretary to Government of India.
Yes.
Your Lordship applies beyond Tata Cellular test now. Tata Cellular is the old case now.
That is true.
So many new cases have come. Your Lordship looks at Wednesbury unreasonableness. What are the tests? Let us look at the test for just 30 seconds. Wednesbury unreasonableness. No material on which you could have come. Taking into account relevant considerations. Failing to take into account relevant considerations. Taking into account irrelevant considerations. Well, it's a case of no reasons, no ratios, etc. Which way it falls is not the point. Your Lordship does full review. On the contrary, when Malas political thicket comes, your Lordships does do review. Malas, the advance of Bommai was to say that your Lordship is not shut out. It is not to say that review is Malas more than normal. It is the other way around. Your Lordship were prior to Bommai shut off. Your Lordships entered much more into review because of Bommai and these other cases coming later. This case which I am on 17A has always been reviewable. I mean, not 17A, but similar. Much more reviewability. So, Malas, and yet, this is the other part. 17A, let us say, is a public servant who is the Deputy Secretary. These are all considerations the court must keep in mind. There is 17A, let us say, qua Additional Secretary. There is 17A, qua Secretary to Government of India. There is 17A, qua a Minister.
To everyone.
And there is, no, Malas, and there is a 17A, qua Chief Minister.
Yes.
So, with a full, robust reviewability of a statutory power, your Lordship has the heightened consequence that the protective umbrella, if not reviewed properly, can lead to an elected government falling, which does not happen. So, as you go up my ladder being Deputy Secretary to Chief Minister, the reviewability becomes more careful, scrutinized and pointed, because there is the additional disadvantage of governments being toppled by this. Otherwise, why do your Lordship create 17A for the higher political part? But there are two parts of 17A. One is the bureaucratic part. One is the political part. The political part has the additional liability that you destabilize. Consider, that's why I said the first para of my submission is that, first para. Your Lordship has something running. Your Lordship has always wrongs in an elected government. Any passerby walks in and says, I want to criminally prosecute after 23 years. The total span is 23 years, active span is 10 years. Then why have a filter, Malas? If you have a filter, then why have a filter which is limited review by your Lordships? If you have a filter, why have a filter where the governor does not exercise objective criteria? But the governor, in a matter like a floor test, must have objective criteria, which is more political. I would say, with greatest respect, Paulus, that this is a more political thicket than the one I am arguing. Therefore, the conclusion is should be the opposite, that your lordship's scrutiny should be more careful and heightened, because your lordship is not in a classic unreviewable political thicket area. Your lordship is, of course, on the straddles, on the margins of both. But Paulus, here it is really, this part is intra-house, where your lordship has 212. Your lordship doesn't go in the house. Of course, the governor is outside the house, but otherwise, Paulus, intra-house is protected by 212. So, Paulus, your lordship is more cautious here. Lordship is more vigorous in my case, is my humble submission. Now, 17. Then comes MP, Paulus. The question was governor, etc. Now come to 8 at page
Yes.
17. This is a very important one.
Yes.
The said decision held. Now, Paulus, first point about MP. Totally misunderstood. Automatic. Take the name cabinet, take the name CM, take the name governor. MP says automatically I can go. Actually, the first two paras of MP say the opposite, which I have quoted. Opposite. Undoubtedly, in a matter of grant of sanction to prosecute, the governor is normally required to act on aid and advice. You have made the exception into the rule. Let us look at the rule first. This is the rule. My learned friend started with the exception, and not in his discretion. However, an exception may arise, mark the word may, while considering grant of sanction to prosecute as chief minister, where as a matter of propriety, the governor may have to act in his own discretion. Similar would be the situation if the council disables or disentitles itself. Suppose, my lords, there is an allegation that 60% or 50% of the council conspired under 120B. The last sentence will apply. Or my lord finds a group of 3-4 people. Certainly, the council has to first consider the grant of sanction. We also presume that a high authority like the council will normally act in a bona fide manner, fairly, honestly. All this is forgotten. It is straight push button, automatic. That's the error. First part. I'm coming to the second part. However, on those rare occasions where on facts the bias becomes apparent. Now mark this sentence, Manoj, kindly. This is the
Apparent
twofold
bias.
apparent bias. And or the decision is not the subconscious or institutional bias. You must be presumptively biased because you are a cabinet. But apparent bias is some demonstration. Some demonstration must be there. And based, I'm sorry, and the decision is shown to be irrational and based on non-consideration of relevant factors, the governor would be right on the facts. First test did not apply in MP. Second test, not applied by the governor in my case. That's the only test applied by MP. Now, let's just see this. Para 9, 18, page 18, para 9.1. Where on the facts there is a case of apparent bias, this did not arise in the facts of that case. Where the decision of the council was shown to be irrational and based on non-consideration of relevant factors. They are the only two tests. Only. And one did arise. And that one is applied in my case. The decision says, now mark these words for us. Now, this is the context in which you should read M. The decision of the Supreme Court does not lay down any presumptive rule that in all cases where the chief minister or member of the council faces prosecution, there is necessarily an apparent bias. This is a question my lord rightly put to me. However, as third line, as stated above, unless a situation arises as a result whereof the council of ministers disables or disentitles itself, the governor in such matters may not have any role to play. No automatic. Taking a cue from Antule, it is possible to contend that a council may not take a fair and impartial decisions when their chief minister or other members face prosecution. But the doctrine of apparent bias, however, may not be applicable in a case where a collective decision is required to be taken under a statute in relation to former ministers. In a meeting of his council, each member has his own say. There may be different views or opinions, but in a democracy, the opinion of the majority would prevail. Mr. Sorabji has not placed any material to show as to how the council collectively or the members of the council individually were in any manner whatsoever biased. Mr. Sorabji is arguing the opposite point of view. This case, my case, Wallace, this is very important. I'm sorry to repeat.
No, we will take it that the Council of Ministers cabinet had suggested something. You admit that governor is empowered to disagree. It is not that he has to follow. He can disagree.
Provided, no,
He can disagree. Caveat, of course. He can disagree. If he can disagree, then why at all we get into all this saying that Council of Ministers and the role of the governor?
I'll tell Lordship.
In the disagreement, whatever you say, he should record reasons for disagreement. That is all.
Little more complicated, than little more.
Yes.
I understand what my Lord is saying. My Lord is saying the governor can decide.
Yes.
Then we just look at the reasons.
No,
My-
is it that whatever the
answer-
cabinet says, the governor says yes? That is not the scheme of the
No,
constitution.
Equally,
Ah.
whatever the cabinet says, the governor can always say no is also not the same.
Yes.
Now, therefore, when your Lordship formulates is thus, the governor can decide. I would like to say, well, that's an incomplete sentence. Let me add the suffix. I would put my proposition as the governor can decide, provided the following 2 or 3 conditions are fulfilled. A, it's a cabinet chief minister or cabinet minister case. That is done. That's the fact. Otherwise, it will not arise. 2 crucial conditions. Can decide if A, there is a demonstration and a prima facie finding of apparent bias. B, if there is shown manifest irrationality. And C, either or both of these must be reflected in the order.
Yes.
This is the correct formulation in my view.
It's all right.
In my-
We'll take it. Now, in MP's case,
Yes.
why did the apex court say it suffered from irrationality?
Yeah, that's coming.
It said because a report was not taken into consideration by the cabinet when they recommended that this should be the action. So the apex court said that that report should have been taken note of and then permitted a prosecution.
And the governor also said so.
Governor had said so.
Governor gave reasons
Yes,
and dealt with it.
yes. No,
I'll check
if
up
you
that
see paragraph 26 onwards of
That's
MP.
exactly what.